I bumped it down, so if y'all get cold, I bumped it down because I'm hot, but if y'all get real cold, just tell me and I'll bump it up.
Well, I said, who you going fishing with? I said, I have no idea. Larry Wise. 25, 30 years.
He's shy and bashful that way, isn't he? I'll just run it by you. I'll do the, make sure this, I'll do the
And then
housekeeping,
you'll turn
and
it
then
over
to
to me.
you.
Yep,
And
3 minutes.
all this new technology looks like they put us a little plush.
That is a question for you, sir, Andrew. Is there technology that I can put on my tablet or speakerphone screen a countdown clock? So that the speaker and everyone is aware of the time?
Eric uses it.
I'm just asking for future.
Hey,
Eric,
hey,
Eric does it, Johnny?
Eric uses it.
There's a way for me just to put something simple up, but I don't know if it matters.
Well, we need the teams also, don't,
Actually, years and years ago, I worked for his brother, Steve Wise, when he had it used to be Bruce Wessinger's, but there was Wise's where they had the peanuts, and what's now Mid-Carolina Animal Hospital, that area.
Was that the filling station across the road?
No, this is not the filling station. This was before Roy and Dean did that. This is on the other side where Mid-Carolina Animal Hospital is. It was a convenience store there. Well, predecessor convenience store. Yeah, it was a long time ago. But we boil peanuts, oh my goodness.
It's amazing. If that the window's open, there's a big car there.
Yeah, that's right. And then Larry's brother, Roy, bought what was the Exxon station. And then his son started that little, what Levers has bought now.
I know Steve, Larry, I know Larry Rowe.
How about that?
I moved y'all down. Torsia can't be with us tonight, and Jeff is using this last seat for his mini office until he's officially retired. So to keep from moving his stuff, I just shifted everybody down.
Okay, thank you.
Do we have a quorum, Katie?
Not yet,
Okay.
but Hugh called me to let me know he was coming, and Ty.
Okay.
How'd you fare as far as ice and snow and all that good stuff?
All right. Had to work through all that stuff. Yeah. Had to be out there at the
Was it
highway department.
bad around your house?
Well, it's pretty bad, man. The ice and stuff in where the shady, and the snow and stuff where the sun hadn't got to.
That's right.
It took a couple of days to
Which one?
get it out.
You want? I'm gonna leave this right here and just whoever comes next. Call this February 3rd, 2026, Newberry County Board of Zoning Appeals meeting to order. And make note that we do have a quorum. I'm gonna take care of some housekeeping. First and foremost, if you can't turn it off, silence it, turn it off. If you can't do that, you can just put it in the hall so we don't get interrupted. 2, consider yourselves under oath when speaking to this body. And 3, when you are speaking, you'll be recognized. You'll come to the podium. There should be a sign-in sheet there. Print it legibly, and then state your name and address for the record because this is being recorded. And when speaking, you'll have 3 minutes. And then after your case is heard and decided, you may exit quietly if there's no other business for you. And at this time, I'm going to turn it over to Miss Katie. I have run out of my time.
All right, at this time, we will conduct the elections for chairman, vice chairman, and secretary for the 2026 year. So I would ask at this time for a motion to open the floor for nominations for our 2026 chairman.
So moved.
Second.
All in favor?
Aye.
All right, do we have any nominations for chairman?
I nominate Ty Ransdale.
I nominate Doug Hill.
Doug
Doug-
served.
Doug has served
I
too.
appreciate it.
Doug is,
You can only serve 2 years.
Yeah.
Oh, well,
I've endured my term of punishment.
you just found an easy out, Doug.
Do we have any other nominations other than Ty Ransdale? Do we have a motion to close nominations?
Motion to
Motion.
close.
Second.
Second?
Somebody did, yeah.
All in favor?
Aye.
All right, so chairman is now closed. At this time, I would ask for a motion to open the floor for nominations for our 2026 vice chairman.
So moved.
Second?
Second.
All in favor? Do we have any nominations for vice chairman?
Nominate Patrick Wilkes. I mean, good buddy.
Any other nominations?
I move nominations come to a close.
Second?
Second.
All in favor, nominations closed?
Right.
All in favor for Patrick Wilkes as vice chairman?
And want the staff to maintain secretary?
Yes, but we will need, because we don't have it listed in our rules and
Yes, ma'am.
procedures, we'll need to go through the process.
Yes, ma'am.
All right, I would ask for a motion to open the floor for nominations for secretary.
So moved.
Second?
Second.
All in favor? Nominations for secretary?
Katie.
Katie Works.
Do we have a motion to close?
I do.
Second, Lister. All in favor?
Aye.
Yeah.
All right, motion passes. All right. I'll now turn over our meeting to Chairman Ty Ransdale.
All right, gentlemen, we've all had a chance to review the minutes from December 2nd, 2025. Do I have a motion or discussion?
Move to be approved as read.
I second that, Mr. Chairman.
All right, all in favor?
Aye.
All right, on to new business. Here tonight to hear case number VA 01-02-03-26. This is for a variance request for the relief of the required 7-foot side property line setback to be 3 feet from the side property line for an addition to an existing building. The addition will be a 30 by 30 and will be enclosed on both sides. The property is located at 1197 Newberry Shores, Prosperity. Tax map number 538-2-8. Do I have anyone, Katie, you want to talk about it here?
So, this case came before you all in a previous 2025 BZA meeting. There was some confusing issues with the motion. The applicant explained how he was going to build it in his presentation, but a question was asked at the end of the meeting of reference to whether it would be open, and the answer was yes. The applicant assumed that y'all knew what he meant, but for clarifying purposes so that everybody is on the same page and we have a clear motion of whether it is approved or not, this matter is going back before you all. So the structure is being added on to an existing structure that is there that was BZA granted back in, I think, 2013. So this structure will be enclosed on 3 sides. 2 sides will be enclosed, and in the rear, it's being attached to an already enclosed structure. So essentially, the rear will also be enclosed because the existing shed is enclosed. The front will not have garage doors or any type of enclosure, so it will be enclosed on the 2 sides and in the rear. And they're asking to be 3 foot from the property line instead of 7.
Ms. Katie, just for clarification, I think when we discussed that, it was to be, an open carport?
Correct. It was listed in the, on the agenda as open carport, and then he explained that he was gonna have the sides on it during his presentation. But again, for, motion purposes and so that we're all on the understanding of how it is actually, gonna be built if approved, we wanted to send it back before you all.
Members of the board, any questions for Ms. Katie? All right, anyone speaking on behalf of the motion? You'd come up to the podium, please, and write your name and address down there. And I just want to remind everybody, as you're speaking either on behalf of the project or against the project, you have 3 minutes.
Okay. My name is Donald Beeson. I live at 1197 Newberry Shores Drive. I appreciate y'all letting me come and address this issue. First of all, I was approved for this addition on 7/1/25. After nearly finishing my project, Mr. Ginn comes up with this nonsense of no sides. And I have pictures that I have already, I'm nearly done. All I like is putting the sides on it. All right? At the time of the meeting, I described how the addition would look. I stated that it would have a roof and sides. Later in the hearing, I was asked by one of you guys, would it be open? And I interpreted that question as meaning in the front, to which I answered yes. And this is the side. It's ready to put the side on it. All right. This picture was taken at 2:05 p.m. showing the sun over 3/4 across from where my vehicles would be sitting. This structure does not work without these sides. You see the sunlight? I built this to protect my vehicles from the elements. It's pretty self-explanatory. All right? I have another reason for the sides to be installed. This snowstorm, if I'd had sides on this building, this would not have happened. And that's pretty much all I have to say at this point.
Members of the board, any questions for Mr. Beeson?
I understand you want to put siding on both sides of.
Yes, sir. Yes, sir.
Okay, all right. Is there anyone else speaking on behalf of the variance? All right. Is anyone speaking against the variance?
Good evening, members of the board. My name is Ben Bruner. I'm an attorney. My firm represents Mr. Ginn. I'm going to give some legal reasons why granting this variance would be a mistake, and then I'm going to let Mr. Ginn stand before you and give some more factual detail about it. My understanding is there originally was a variance granted a long time ago, and now we're adding on to that. When are we going to stop adding on to that, I ask you? But legally, the county's ordinances require specific findings to grant a variance. These aren't things that the county came up with on its own. These are things that the General Assembly in the South Carolina Code of Laws require all counties to include in their zoning ordinances. The ordinance at issue is section 153.052C, and that codifies South Carolina Code section 6-29-800, which says that a board like you gentlemen has the ability to grant a variance only under limited circumstances. You must find, number one, extraordinary and exceptional conditions apply to this property. There is nothing extraordinary or exceptional that I've heard so far. Protecting vehicles, I understand a man's desire to protect vehicles, but that does not make his property extraordinary or exceptional so as to require a variance and meet this standard. A historic snowstorm does not meet that standard. He has to show the movement asking for the variance from you gentlemen has to prove that those circumstances at his house on his property do not generally apply to nearby properties. I have not heard anything that distinguishes his property from any of the other properties around. Everybody's house got snow. Everybody's home is subject to the elements. There's nothing setting this property aside. He also has to prove that granting the variance, and you have to find, gentlemen, that granting the variance would not be a substantial detriment to the adjacent property or the public good. And what we're talking about is a variance allowing him to build a building closer to the property line. Mr. Ginn is going to talk more about the detriment to his property. But if he finishes this structure and if the variance is granted, gentlemen, how is that not going to impact the amount of sunlight that comes across the property line, the view of the lake?
You have about 10 seconds to wrap up.
Thank you. Finally, you'd have to find the variance would not allow an otherwise prohibited use or extend nonconformity. There are other factors, gentlemen, which I think your attorney can tell you about. They are simply not here. For that reason, I'd ask that you decline this variance. And I'll see you on the other items a little bit later. Thank you.
All right, anyone else speaking in favor? Mr. Beeson, do you have anything for a rebuttal on his?
Yes, I do. First of all, I've already been granted this variance. Second thing, the only thing I'm here for is to make y'all understand what I was gonna do in the beginning, and that's put sides on this, building. And as far as this building affecting his view, he'd have to be standing at the road in his driveway looking down to the lake for it to obstruct any of his view of the water or the lake. It is not in no way, shape, or form affecting any of those things. So, that's pretty much it.
All right. Anyone speaking against Mr. Ginn, come on up. Thank you.
Are we ready, sir? I just want to make sure.
You ready? Go ahead.
All right, I appreciate y'all listening to me. Mr. Beeson has already,
State your name and address.
my name is Gary Ginn, and I'm speaking on behalf of 1203 Newberry Shores Drive.
Okay, thank you.
Mr. Beeson had already applied for this permit on July 1st, and he was granted a variance to build a carport, as Ms. Katie Wirtz stated in her address to this board before anybody else had a chance. Of course, I spoke against it. He was granted the thing, but it says on your grant that was approved, it says that a 30 by 30 three-sided open carport to the existing building. That's what y'all granted. When he was given a permit for this building, on the permit, it says a 30-30 addition to existing shop. That was on the ordinance permit, and that was on the building permit, which they don't coincide with each other. The variance was never approved to build an existing shop, storage shed. It was approved to do a three-sided carport. When the building permit was issued in the description, it said 30-30 addition to existing shop. Nowhere has Mr. Beeson ever asked to build a shop on his property. The permit was issued to build a storage building in 2013. On January 7th, 2026, picture number 1, which is a picture of what he's started, I asked Mr. Beeson in person about the boards on the side, and he replied that there would be sides put on the boards. I responded that he was granted a variance to build a carport. Legal definition of a carport, 2 or more open sides. He replied was going to build a carport. Legal definition of a carport is 3 or more open sides. Mr. Beeson showed a video of the BZA meeting with him describing it as a carport, not a storage building, in which that video he said carport 3 or 4 more times. Ms. Wirtz and Mr. Beeson reiterated that this was not going to be a storage building and never said anything about a shop addition. Tiffany and Gary Ginn opposed this at the BZA meeting on grounds that an 80-foot building down the side of his property line was too much. It cuts off natural flow of air and sunlight. The building is so tall that the sunlight in the afternoon never hits my side of the yard, not Mr. Beeson's side of the yard, but my side of the yard. Without the sun hitting the yard, I have a septic tank in that
About
yard,
10 seconds to wrap it up.
which doesn't allow the septic tank to work right. Grass and shrubs will not grow without afternoon sunlight. Covering up tree roots put a strains on a 100-year oak that sits on my side of the property. The large building
Okay,
hurts
Mr.
the
Ginn.
future of my property value.
Thank you. Members of the board, any questions, discussion?
when the initial variance was granted back in July, Mr. Gann, you said you objected at that time?
Yes, sir.
Okay, and the motion was granted over your objection.
Yes, sir, it was.
But the motion was also approved, it was to be an open shed. Is that correct, Ms. Katie?
It was, I don't have the staff report for that meeting, but it was explained to the board that it would be an addition to what he already had there. The sides is where the problem arises, but it was told to the board that it was going to be attached to the existing structure that was a variance granted in 2013.
Mr. Gann, I think you said that, a carport has two or more open sides,
Two
or
or more
three,
open sides, sir.
two or more open,
Yes, sir, according to the legal definition. Mr. Lister, may I speak?
You can
go
approach.
through the chairman.
You can approach.
On your package there, I also attached the approved minutes of that meeting on the meeting of July 1st. I attached that with your approved stamp on it. And on that approved stamp, on that meeting, it also says 3 open sides.
So, in the reality, this is going back before you all as a whole. So what was done, this is a whole new case. Am I correct, Joni? We're hearing this as if you've never heard it before, with new details added into the case.
Mr. Chairman. Okay. Mr. Beeson, anything you'd like to add?
Yes, I would. If y'all will go back to the meetings, I specifically 100% said it would be a carport-like structure. I didn't say it was gonna be a carport structure. I said it's gonna be a carport-like structure, and it would have sides. And it's in the video, it's 100% there. I showed that to Mr. Ginn. He said, I don't understand what that means. That was his exact words to me. I don't understand what that means when I showed it to him.
Mr. Chairman,
Yes.
can we see the pictures? Pictures
I
that
need-
Mr. Beeson
The
has?
pictures.
I don't mean to string this out.
Yeah, no, it's, yep.
Make sure I understand.
Go ahead. Katie, will you need to have these in for your record?
Yes.
Let's see what he's talking about.
May I ask a question? Ms. Katie, does this board have any control over the permit that was issued? The way it was written or anything?
After tonight's meeting, whatever the decision is, then we can change, if needed, that permit to reflect what is decided by this board.
Okay, all right. So it's like you're forgetting the past July
Correct.
1 meeting, okay.
Okay.
It just seemed like a lot of emphasis was done on the permitting.
Members of the board, any other discussion? Questions? Are we ready to close all comments? Do I have a motion to approve closure of comments from the floor?
I have one more question. I'm
Yes.
sorry. You're asking for the setback to be 3 feet instead of 7 feet. Does that mean that the building or addition would be only 26 feet by 30 feet as opposed to 30 by 30?
No, sir, the variance is on the side property line, a building must be 7 foot
Right,
setback. He's asking to be 3 foot from the property line.
okay. I'm just looking for the,
And I think Joni wanted to add something in. Joni?
I did, if I could, Mr. Chairman, if the commission could sort of analyze what Mr. Bruner brought up, the requirements for a variance. He mentioned a few bullet points that are required under both our ordinance and the state statute. And if you could just take a look at those, I'm sure Mr. Bruner would be happy to repeat them for you. There were only 3, I think. Well, I got 3 written down. If y'all could analyze those and in your deliberation, that would be helpful, because I think that's the law. Okay, that's the law right there. So if you all would do that, and also if Mr. Bruner could also answer the question, this is for me, because I'm at a disadvantage, Mr. Bruner. I do not have the code with me right now. It's been mentioned a few times what the definition of carport is. If you could tell me, give me a citation on that, that would be great.
I'd be happy to first address the variance requirements. That's under Title 6-29-800. And I can get into those with the carport definition. That came from Mr. Ginn, so I need a little bit of a moment to find that materials.
You didn't give that legal opinion.
I have not defined a carport, and I could look into your zoning ordinance and see if that's defined in there. I'm happy to help out and help facilitate this as best I can, but first, let's go through the elements of.
Sure.
So they're gonna, once the board closes this to discussion, the board individually reads these, and each individual member must answer, so that will be addressed.
Our dear friends, 153.052C, 1 through 5.
finding of fact.
Do you still want him to go through them, Joni?
No, Katie, as long as they address them.
Yes,
that's-
they
I
will,
just want that
the chairman will
done.
individually
Yeah.
read these, yes.
As long as those are addressed and there's a record of it.
Yes,
you know,
that's protocol in all of our meetings.
We will go through the finding of facts through all 5, and each board member will vote on each one individually.
Okay.
And
Awesome.
it should have been done
Okay.
in July.
Yeah.
It was done in July.
Okay, thank you.
Okay, and I'm looking
And-
for the reference on carport. It may be in the definition section of the ordinance. Bear with me.
Because Mr. Ginn did refer to it as the legal definition. I just want to know what the citation is.
May I? I did look it up, and the definition of a carport refers to how many sides of a carport. If it has more than 2 open sides, it is a carport. If it is closed, 2 or more sides are closed in, like this will be 3 sides closed in, then it is either considered a garage or a shed or a building.
And what section of the code states that?
It's a South Carolina code that I looked up on the internet, so it does state that. I do not have that number. It's a building code in Newberry County. Building code. And South Carolina.
It's under our ordinances?
It's under everybody's ordinances in the state of South Carolina.
I think what he's saying is he looked it up in a building code, which would have been incorporated by ordinance, because the International Building Code and the Residential Building Code are typically incorporated.
They get adopted. Right, they get adopted. I get that. I just want a citation. Okay, thank you.
Ms. Tony, are you good?
Yes, sir.
Okay. All right.
So, Mr. Chairman, are we going to take into consideration if this structure can stay, but the sides are going to have to stay open, or is this just going to be an up and down vote on if it can stay with no requirements that it stay open or anything? I mean,
With the variance that we're being heard in front of is the required 7-foot line setback to the 3-foot side setback. And then it's the addition to the 30/30 and will be enclosed on both
Yeah.
sides. So that's the case that we're.
so it's up and down. If we don't approve it, it's got to come down, right?
That is
Okay,
correct.
Okay.
That is correct. Yep. Any other discussion from the board?
But the building that this structure is being attached to is 3 foot from the line now? Somebody?
34.5 inches.
Okay. So it would just,
The one that they're putting on now is 40 inches.
but it would be just continuing the straight line. Correct?
No, it's-
Well, I mean, you're just attaching to a existing building,
No, it's.
structure.
Yes, I'm attaching to it, but I'm not going to the side. I'm moving in about 6 inches
Okay.
or so to get it legal on the distance
All right.
from the property line.
Well, 40 inches isn't 7 feet.
He's asking for a variance to be
Well,
3
that's-
foot.
So round numbers, you're talking 3 feet instead of 40 inches then, is that correct?
That's correct.
Yeah.
But, like I said, that's already been granted,
Yeah,
so.
but you were saying to get it legal, I mean, that would,
But
40
again,
inches doesn't make it legal.
we're hearing this like for the first time, so this is what the request is in front of us.
Yes.
Okay. Other discussion? Do I have a motion to move for closure of discussion?
So moved, sir. So moved.
Okay. Yep, do I have a second?
I'll second.
All in favor?
Aye.
All right. All right, board, let's go to the findings of the facts. And this board is required to consider the following factors per section 105.05. This is A through F of the zoning ordinance, and we're going to review 105.3.052.
Excuse me, Mr. Chairman, it should be 153.
153.052, section C, and 1 through 5. Got it? All right, number 1, there are extraordinary and exceptional conditions pertaining to a particular piece of property. Mr. Patrick, I'll start to my left.
Agree.
Disagree.
Disagree on that one.
Mr. Wayne?
Disagree.
Mr. Doug?
I agree.
Pardon me?
Yeah, we got three.
Okay.
And then your vote.
I disagree. All right, number 2, the conditions do not generally apply to the other property in the vicinity or in that district.
Disagree.
Mr. Hugh?
Give me a minute. I would agree.
Mr. Patrick?
I'm gonna disagree on that one too.
Agree.
I agree.
And I'll agree on that one. All right.
Mr. Chairman, if I can-
Yes, ma'am.
Mr. Chairman, if I can interrupt. If, I understand the commissioners are agreeing or disagreeing, but can we have some analytical conversation as to why?
Sure, we can, we'll back up to number 1. Are you wanting for both, whether they agree or disagree?
Yes, sir.
Okay. All right, so I'll read number 1 back to everybody. The extraordinary and exceptional conditions pertaining to a particular piece of property. For those that disagreed, you want to talk about that?
You want to just go back in order?
Yep. You had agreed, Mr. Patrick. Can you discussion why?
Well, as I recall, is with the piece of property he had, this was the only place he could really put this carport. He was limited where he could put it on this particular piece of property. And had to get the variance down to 3 foot because of the encroachment on the line. There was nowhere else he could put it.
Okay. Mr. Hugh, you disagreed?
I disagree, but I don't see anything particularly exceptional about this piece of property. It is not obstructed by a septic tank or other buildings or structures or whatever that might prevent him from building the building. So I don't see anything exceptional about the property.
Okay.
Neither do I, Mr. Chairman.
Same as me on it, also there.
Yeah, and I disagreed as and I don't see that either.
Well, where I saw, I agreed with it because he's attaching to an existing structure that was already within that.
Okay. All right. Ms. Tony, any questions for the board?
No, sir, that's exactly what we need. I appreciate that.
Yes,
Thank you.
ma'am. We'll do that for each one of them.
Yes, sir.
We'll go back to number 2. These conditions do not generally apply to that are proper in the vicinity or in the district. Mr. Patrick, I know you disagree.
These conditions do not generally. Well, I don't think every other property, is having the same problem with this narrow lot here. I think this is unique to this piece of property.
Okay. Mr. Hugh, you had
I agree, and essentially the same thing that Patrick said. They don't generally apply to all the other properties in the vicinity. It's specific to this one particular piece of property.
Mr. Meeks?
I agree or disagree? I think I agree.
You disagree?
Disagree, right.
Okay. The reason I kind of made my judgment on it, that this was being open and stuff like that, other property owners around there, it's kind of includes part. That's kind of part I agree on.
Mr. Wayne, Mr.
I agree.
He wants to know why. Ms.
Well,
Jones
it's pretty much self-explanatory. It doesn't apply to other property, in my opinion.
And I agreed, and I didn't think that it was applied to
Yeah,
other.
all right, the same as me. All right. All right, let's go on to number 3. Because of these conditions, the application of the ordinance to a particular piece of property would effectively prohibit or unreasonably restrict the use of the property. Patrick, if you'd go ahead and tell us whether you agree or disagree and why.
I reckon I'd say I disagree with that. I don't think it's gonna, prohibit unreasonably the use of the property. I don't see where it would, no.
I would disagree with that statement for the same reason that Mr. Patrick Wilkes spoke. I don't see that the application of the ordinance would restrict the use of the property in any way. Might restrict what he wants to do with it, but it won't restrict the use of the property.
Okay, so you both agree with that statement?
I think we both disagree.
Disagree, okay.
What you described, you agree.
Pardon me?
What you both just described as your reason would be in agreement to that.
That's what I
Yeah, I
understood.
think
That's
you're
why I was
right.
asking for
You're right.
clarification.
Yes.
So are you agreeing?
Yes.
The application,
You-
you know, would, I think it's disagree.
Okay.
If we apply the ordinance to the property, it would prohibit, we're saying it's not gonna prohibit the use of the property.
Do you agree or disagree with that statement?
Let me see, because
Based on the
We're
way
talking
I'm
about
reading that
Mr.
statement, I
Beeson's, the
disagree.
property owner, will this, if he cannot, if he's saying, will, if you say no, are you restricting this property? Mr. Beeson's property?
I mean, no, it may, like he may not be able to put the garage there, but it's not restricting the use of the property, no.
Okay.
Okay,
So we're back again.
back again. Okay,
So he's
Okay.
That's what you
disagreeing.
were saying, yeah.
okay, all right.
Is it me?
I disagree with it, same
Okay.
thing, because they prohibiting him from his property.
Okay,
I agree, Mr. Chairman.
all right.
And I agree that he wouldn't be able to put it where he wants to with the implementation of this or variance without it.
And I agree as well for the same, Mr. Hip, as far as the
Well,
property.
I think what may be confusing me is talking about the property, not the shed, or the structure, or whatever he's proposing to put. You know, the way this reads, it affects the use of the property, but it is not saying that about the actual structure he wants to put on it.
That's how I'd interpret it as well, is it's restricted use of the property.
Yeah.
Okay, are you in agreement with that statement?
I'm still in disagreement.
You're still in disagreement, okay. All right, so I've got 3 disagreements and 2 agreements.
3 and 3.
3 and 3.
3 and 3, sorry, 3 and 3. All right, number 4, the authorization of the variance will not be a substantial detriment to the adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance.
I disagree with that. I think with it being enclosed, I think it is going to affect the adjacent property there, since it's so close to the property line.
All right. Mr. Hugh?
I'm with Mr. Wilkes on that. I do feel like it would be a detriment to the adjacent property.
Okay. Mr. Wilk, Mr. Patrick, meets,
I disagree on
you
it.
disagree as well?
Yeah, because
Mr.
of the closing of the detriment to the next property owner.
Mr. Boland?
I disagree as well, Mr. Chairman, due to the fact of what I've heard here from the adjoining property owners, it could very well be a detriment to adjacent property.
Okay. Mr. Bull? Ms. Tripp?
Unfortunately, with the closure, I would have to disagree.
And I disagree as well for the same reason for the adjoining property. All right, number 5, the effect of the variance would not allow the establishment of a use not otherwise permitted in the zoning district, would not extend physically a non-conforming use of the land, would not change the zoning district boundaries shown on the official zoning map.
I'll agree with that. I don't think, if we did grant the variance, I don't think it's going to be changing, permitting things that's normally not permitted in the, district garages and things like that. So,
I agree with that also for essentially the same reasons. It's not going to change the zoning district boundaries as shown on the zoning map.
I agree on that too, because of the zoning map. Won't change it.
I agree for the same reasons.
Ms. Tripp?
And I concur. I agree for
Concur.
the reasons stated
All right.
before me.
All right, I agree with that as well. All right. Members of the board, we've all heard the findings of facts. I'm going to go down through them, and I know a couple of other people have been doing the tallies, but for number 1 of the section 105.052, and I'm going to read these out loud again. Number 1, there are extraordinary and exceptional conditions pertaining to a particular piece of property. There was basically read my writing, it was a 3-3 split on that, 3 in favor and 3 opposed. Number 2, the conditions do not generally apply to the other property in the vicinity or in the district. It was 2 opposed and 4 in favor. Number 3, because of the conditions, the application of the ordinance to a particular piece of property would effectively prohibit or unreasonably restrict the use of the property. It was a 3-3 split, 3 in favor, 3 opposed. Number 4, the authorization of the variance would not be substantial detriment to the adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance. All 6 of us opposed that. Number 5, the effect of the variance would not allow the establishment of a use not otherwise permitted in the zoning district. It would not extend physically a non-conforming use of the land, would not change the zoning district boundaries shown on the official zoning map, and we all agreed on that. Members of the board, do we have a motion?
Mr. Chairman, with the finding of fact that we have been through, I'm afraid we cannot grant this variance. I move that we not grant the variance.
Do I have a second?
Wait a second. Who seconded that?
Mr. Wilks? All right. Do I have all in favor by saying aye?
Raise your hands.
Of what?
All in favor of opposing.
Opposing the
not
variance.
Granting.
Okay. All right. Mr. Beeson, that variance has failed, okay? We're not granting that variance at this time. All right, we're going to go on to the next one. And this is going to be case VA-02-0203-26. This is for the variance request for the relief of the required 7-foot side property line setback to be 5 feet from the side property line for a 10-by-10 enclosed storage building. The property is located at 1197 Newberry Shores Prosperity, tax map 538-2-8. Ms. Katie?
So again, it's a variance request for the relief of the required 7-foot side property line to be 5 foot from the side property line for that 10-by-10 enclosed storage building.
Members of the board, any questions for
The
Ms.
building
Katie?
is existing on the property.
The building's already there.
Yes.
Questions for Ms. Katie? All right, do I have anyone speaking on behalf of this variance?
Can I address the other issue that y'all voted on? I would like to state again,
Mr. Chairman, I don't think we.
Yeah, Mr. Chair,
can I?
we've already heard that already.
Okay,
We need to move on to this variance,
okay,
and you've got 3 minutes.
all right. This is the building that's in question. It's 5'6" from the property line. It was there when I bought the property.
Y'all see that, or you want him to?
I can't see.
Yeah, what?
You can't see it.
Yeah. Pass that around.
Thank you.
You can go ahead if you'd like.
Don't document first time.
Okay.
I think he wants that picture back, so you just note something bottom.
Oh,
They'll have to submit it into record, too. Katie will need it.
Okay, the green structure by the tree is,
That's the back of
building,
the
okay.
building. And it was there when I bought the property.
thank you.
That white string you see there pulled is the property line.
You need this back for your,
Yes.
Did need it for your notes on there? Yeah.
beat you halfway.
All right, Mr. Beeson, we'll let you go ahead and continue.
Well, this building was here was there when I purchased the home. It's 5'6" from the property line. Gary has a storage building behind his house. It's 5 feet from the line. If you noticed all that water that is on the ground there, that come off of his house, he wants to complain all the time about my building putting water on his property. Then right there, he has no gutter and his overhang is over my property line. So that's what I have to deal with.
Okay.
May I ask you?
Yeah, go ahead.
Mr. Chairman, may I ask a question? How long have you owned this property?
13 and a half years.
Was there ever any issue prior to that? Or let me rephrase that question. When did this question come up about the need for approval of the variance since that building was already in place?
When Mr. Ginn approached me about the sides on this addition to my garage, he started questioning what kind of, he said, do you have gas stored in them buildings? And I told him I've got lawnmowers in there, it's got gas in them. And he said, well, what if my insurance contacts you and says that you need to move one of those buildings out further? I've got two buildings. One of them was closer than that. I jacked it up and moved it out. It's 7 feet. But, and the reason I did that was because I put that building, I moved it from one location on my property. And him being, if you see the property line there, he's about 18 inches, his house is 18 inches from the property line. So I figured if I put my building, the other building, 3 feet or more away from his house, then he couldn't say much about it. But I was wrong, and I moved it out, and this one has been there, since I bought the property.
You have not touched that
No, sir.
building location. It
No.
was at that location
Nope.
when you bought the
I
property.
have not.
Okay. I guess my next question is, Ms.
Yes, Joni, it still needs to go before the board, correct?
Uh-oh.
I think she's gone away.
No, I just went off my, yeah.
Yes.
Okay. All right. All right.
So we need to hear
We
it
need to hear it, yep. All right, so,
because it's 13 years old. Okay,
Yep.
thank you.
yep. All right.
All right.
Is anyone speaking against this? Yes, thank you, gentlemen. Ben Bruner again for Mr. Ginn. I'm going to try not to take my full 3 minutes this time and not waste your time. I believe there's a handout in your packet that's been provided by Mr. Ginn that includes this photograph dated 2013, and it shows the building at issue, which, contrary to what Mr. Beeson just told you, it shows that the building at issue, in fact, was further away from the property line when he bought it. And this structure right here, which is the one we're talking about, has now been moved closer. So the building we're talking about, in fact, has been moved since he bought the property, and that, gentlemen, makes a material difference to your decision. This is not a building that's been sitting in place for 13 and a half years or longer, and an angry neighbor is just trying to cook up problems. In fact, the building did exist on the property in a different location because it's a 10 by 10 storage building that you can go buy at Lowe's. There is a timestamp on that photograph, and I think that's pretty good evidence that there's no way this board can make the findings of fact required to grant a variance. In fact, what that photograph shows more than anything is that this exact building can exist and be used, and the property can be used for the exact same purpose without this variance. It just needs to be moved to comply with the ordinance. I can go through all the details, but I think you gentlemen know where I'm headed with this. I'll answer any questions if you have.
Thank you. What is the white line in this picture?
I believe that's supposed to represent the property line.
And how far is the building on the left side of the property line close to the property line?
I do not know the answer to that question. Mr. Chairman said that I'm under oath. I'm of course here as an attorney advocating for my client, but I can tell you honestly and truthfully, I don't know the answer to that question.
All right.
What we know is, based on this timestamp, as of April 12th, 2013, you're talking about the small storage building on Mr. Ginn's property.
I don't know whose property this is.
On the left-hand side of the property, we know that the building at issue before this board tonight was further away from the property, and that building on the left-hand side was existing. I think that would be, if that's an issue, that'd be an issue for another day. And I hope it's not, but I have a feeling.
The building on the left side of my building.
Hang on.
No.
You got about 10 seconds. Okay. Any more questions?
I don't have any.
Okay. All right. Mr. Beeson, you have a rebuttal?
First of all, that building, the one that I showed you a picture of, that was 5'6" from the line, I have not moved that building since I bought that property. I moved the other one, and I think it's a 8 by 12. But that's all I can say. When I bought the property, it was there.
Board members, any other questions? All right. Mr. Ginn? Wait,
That building here on the, what we,
hold on a second, Mr. Ginn.
building we're looking here with the drain pipe and all that, that's, which property owner? The one on this side?
I'm not sure which picture you've got there, which? That's the side of the shop, right? This one here,
That's the building we were discussing right there.
this one here.
No, this building right here, that's on Mr. Ginn's property. This is Beeson's property.
Is this so for clarity, so this is that 10
This
by
is
10
the-
storage building?
No, that picture is the building that was approved back in 2013, what was before y'all tonight was being added to.
I got you.
The storage building is not in this picture.
Okay. That's where it gets a little confusing.
It's a little
Okay.
confusion there.
All right, that's where it gets confusing. Okay. All right, thank you for that clarification.
I couldn't
Good
make that
question.
one.
No, very good
Two different
question.
cases, you know.
Yeah. Any other questions? Mr. Ginn, go ahead.
So the storage shed is too close to the fence in the house. Ordinance says 7 feet. When storage shed is put on the lot, when the storage shed was put on the lot, was it permitted in a building zone thing? Picture shows a tree. You have a picture of a tree falling on my house, actually, is a cedar tree. That's the back picture, and there's a ladder there. Well, at this existing time, in 2015, there was no storage shed there. So, picture from the second from the back is a picture of my storage shed, which was built there before the building in 1992, and it met the requirements of Wyman Boozer, who gave us property things, we couldn't build anything within 5 feet of the property line and 50 feet from the lake. That was his rule because he still basically owned rights to my property until I paid him off. The third picture from the back is a picture of my house and Mr. Beeson's house, and that was 4/12/2013, and there's no storage shed there. And the fourth picture from the back is a picture of Mr. Beeson's storage shed that is sitting where his steel building sits now. Because if you look behind it, there's a stump, and it's actually right parallel to my storage shed.
Is this the picture you're referring to right now?
Yes, sir, I am. So this storage shed now sits back in that side window of my house behind the fence on Mr. Beeson's property, and it is, according to Mr. Beeson, it is 5.6 feet from my house, and I'm very concerned, even with that being 5.6, I'm very concerned with him storing gas or flammables in that building. If he stores flammables in that building and it were to catch fire, then the fence, his wood fence is going to catch fire, and possibility of my house burning down. And with his steel building there, there's no way, it would be very hard for a fire truck to get behind his house if they had to come in from his side. There would be no way for a fire truck to get in there to put my house fire out or his building fire out.
So if he moves it to the 7 foot, you'll be fine with him storing gas in
I will
it?
be fine with him doing whatever.
That foot and a half will make a difference, you
Yes,
think?
sir. State code,
I understand the code, but that's gonna make you feel safer.
well, state fire marshal
Okay.
code says that 10 feet from the property line of an existing structure, and it has to be, if it's storing gas, It has to be 25 feet.
Yeah, but that ain't, here,
Okay.
you're saying you're okay with 7 foot, right?
If he moves it
Okay.
where it's supposed to be, he never got a zoning ordinance to move it.
Okay. Board, any other questions, discussion?
In one of these pictures, there's a fence. Is that fence still there?
Yes, sir. That's Mr. Beeson's fence.
But I don't see that fence right where it's,
That fence was put up in about 2014, 2015.
okay, so that's why it doesn't show up in these pictures.
Yes, sir.
Okay. All right. Members of the board, any other discussion? Joni, any comments before we start going through the findings of facts?
No, sir, you guys are doing a great job. Thank
All right. All right, if there's no other comments or questions, I'm going to move all the comments closed. Do I have a motion to close all comments from the floor?
So moved, Mr. Chairman.
Second, all in favor?
Aye.
All right. All right, members of the board, here we go. All right. Here's the findings, the facts from 105.052, section C, 1 through 5. And we'll do the same thing we did last time as we go through. Did you make your vote? So I'll start off here. We'll continue like we did last time, going left to right. So, all right, number one, there are extraordinary and exceptional conditions pertaining to a particular piece of property.
No, I would disagree. I don't feel like there's nothing extraordinary here with this small building,
Okay.
you know.
I disagree also, for essentially the same reasons. I don't see anything exceptional about this particular piece of property.
I agree too, on that too, because it's small shed and stuff.
Disagree as well for the same reason.
Sure.
But I agree because this was an existing building. So I agree.
Mr. Ip, I'll agree as well with the existing building. All right, number two, these conditions do not generally apply to the other property in the vicinity or the district.
I would disagree with that. I think they could, I mean, yeah, I disagree with that. I mean, I don't think there's nothing here exceptional. I think this could be applied to any of the properties there in that vicinity.
All right. Mr. Hill?
Well, I agree with that statement that the conditions do generally apply to all the other property in that district, in that vicinity. Everybody's under the same restrictions of the setback being 7 feet.
I agree on that too, because, everybody got to meet the 7-foot requirement.
Okay.
I know it's already existing.
I agree as well, Mr. Chairman.
And I agree as well, because it looks like it was a building exactly like the one that he wants moved right across the line from.
Okay. I agree with that as well. All right. Number five, because of these conditions, I'm sorry, number five. Number three, because of these conditions, the application of the ordinance to a particular piece of property would effectively prohibit or unreasonably restrict the use of the property.
Disagree. It's not going to it's not going to unreasonably restrict the use of the property, no.
I would disagree as well. I'm in agreement with Mr. Wilks. I don't see any way that would prohibit the use of the property.
I disagree also.
Disagree as well?
I don't restrict the property.
I disagree for the same reasons as Mr. Wilt.
Mr. Tritt?
I agree with because we're asking to be moved in an existing building.
And I agree for the same reason with the existing building as well. All right, moving on to number 4, the authorization of the variance will not be a substantial detriment to the adjacent property or the public good, and the character of the district will not be harmed by granting of the variance.
I agree with that. I don't feel like a foot and a half is going to make that much, is going to harm the adjacent property there.
I agree as well. I don't see how it's going to impact the other building that's already there,
I agree with
the
you.
neighbor's property.
Okay,
I agree with it.
I agree as well.
all right.
And I also concur, Mr. Chairman, for the reasons stated above.
All right, and I agree for the same reason as well. All right, number 5, the effect of the variance would not allow the establishment of a use not otherwise permitted in the zoning district, would not extend physically a non-conforming use of the land, would not change the zoning district boundaries shown on the official zoning map.
I agree with that, Mr. Chairman.
I agree as well, Mr. Chairman.
I agree on that, Mr. Chairman, we'll change it.
Agreed, Mr. Chairman.
All right,
And I agree.
I agree as well. It doesn't change the zoning map whatsoever. All right, I'm going to do like I did last time. I'm going to go back through these for the members of the board. Number 1, there are extraordinary and exceptional conditions pertaining to a particular piece of property. There was 4 against, 2 in favor. Number 2, these conditions do not generally apply to the other property in the vicinity or in that district. There was 1 against, 5 in favor. Number 3, because of these conditions, the application of the ordinance to a particular piece of property would effectively prohibit or unreasonably restrict the use of the property. There was 4 against and 2 in favor. Number 4, the authorization of the variance would not be of substantial detriment to the adjacent property or the public good, and the character of the district will not be harmed by the granting of the variance. All 6 of us were in favor. The effect of the variance would not allow the establishment of a use not otherwise permitted in the zoning district, would not extend physically a non-conforming use of land, would not change the zoning district boundaries shown on the official zoning map, and we were all in favor. Members of the board, do I have a motion?
I move the variance be granted.
Second.
What was the motion, Mr. Chairman?
He moved
To grant the variance.
variance.
Clarification, we've got 2 of the facts of findings that were against those.
Yeah, that's not.
So just, but if we got a motion to approve. Do it. Did anybody oppose? All in favor? Granting of the variance as requested?
Aye.
Okay. All right, Mr. Beeson, that variance is granted. All right. On to the next case. All right, this is case number VA 03-02-03-26. The variance request of the relief from the required 50-foot setback from the 360-foot contour of the Lake Murray for a privacy fence. The application is requesting approval to leave the existing fence 3 feet from the 360-foot contour of Lake Murray. the property located at 1209 Newberry Shores, Prosperity. Ms. Katie.
So this fence came before you as an administrative appeal, being within the 50-foot from the 360 contour. After going through mediation, the mediator sent out a document saying that the fence needed to be within the 50-foot. After consulting with Joni, the county administrator, that applicant does have the right to ask for a variance, as any other property owner would have that right.
Okay. Any questions for Ms. Katie?
This is the case where we had to get a definition of the fence.
Yes, this is the fence that, there was two cases, one against the siding of the fence to the property, and the other case was that it was, should meet setback of the lake.
The definition of finished fence, I think, is what we,
Finished fence, and then that should a fence be required to meet setbacks of the lake.
okay?
Yes. And we defined the fence, and that's not the issue, it's how far down it is.
Correct.
That's the issue.
How does the ordinance read? Does it talk about a structure, or does it talk about a fence, or what?
It's, the way I interpret it, the fences are not, part of that, but some interpret it that that a fence is a structure that would have to meet. So that's why we're here tonight, and, county council is, has a text amendment before them clarifying, but that has not gone through yet.
Okay. Other questions, Ms. Katie? All right, do we have anybody speaking in favor of this variance?
How you gentlemen doing?
Good.
Greg Pierce is my name, and I live at 1209 Newberry Shores, where it's one of my secondary residences. And correct, I am here for the second time. I'm not real sure why. I had a long speech planned, but I'm gonna make it very quick because I know everybody wants to go home. The last time I came here, I couldn't talk. I had to listen. But I received this in the mail, which shows where the 47-foot mark would be, that someone from
Lucas Land Surveying.
went onto my property and posted this. Have you seen this? Would you like to see this, where this mark is, where they're suggesting that I
Yeah.
take?
Start down there with Mr. Hugh.
Thank you, Mr. Bill.
Thank you, Mr. Pierce.
When I built this fence, I built the fence because I rode all over the neighborhood, and there are hundreds of people there that have fences. Not only do those fences don't adhere to the setback, but within 4 blocks of our house, Mr. Gins, Mr. Beeson's, are house after house after house that have fences, not only going to the 50-foot setback or the 360, but all the way down into the water. Would you like to see these? These are just a few. I have hundreds of others. No, I could be wrong. My question is, who regulates it? And if I have to take my fence back to 50 foot on this side of the 360, what about all these other people in Newberry County? This subject never came up the last time I was here. This has nothing to do with the fence. This has to do with Mr. Ginn's attack and harassment on me since I bought this house 2 years ago. And it's plain and simple. There's nothing in this $40,000 fence that's offensive to anybody. And if you deem that that's an ugly fence and it's harming him in some way, then I get it. But what about all these other people in the county? Why can my neighbor have a fence that runs all the way into the water, but yet I gotta pull mine back? My fence now was at the 360. Now they want to pull it back 47 more feet. And that's really all I got to say. I don't understand.
I understand.
Members, board, any questions for Mr. Pierce? All right. No other questions? Anyone speaking here against this variance? Thank you, gentlemen. Ben Bruner again for Mr. Ginn. This case is a little different because this matter did come before you gentlemen last year. There was an appeal to the circuit court. There was a right to mediate, which is in Title VI. It's a statutory right. That mediation was performed by former Chief Justice Placonis. And during that mediation, the result was, and you should have a copy of the mediated settlement agreement. There's a mediated settlement agreement that was signed by the parties that set forth a course of action which to date has not been carried out. I'm going to repeat that. This board, as a party to an appeal pending before the circuit court, agreed to a course of action that to date has not been carried out, and I'm not placing blame on you gentlemen, but I'm here to point that out because if this mediated settlement agreement is breached, then that opens the county up to exposure. And if it is breached because of direct communications with the property owner who wants to keep his fence, which, by the way, there is zero dispute, violates the ordinance, then that makes it worse. What I heard is, sure, there's an ordinance, but everybody else violates it. Why can't I? You know why those other folks get to keep their fence? They get along with their neighbors. Isn't that what we should do? Isn't that what we should do? Instead of say everybody else gets one, so I get to have mine and you can't stop me? Well, here we are, taking up your time. You have to go through these same factors. And by the statute, I want to point out, you have to make findings of all of these factors under the ordinance. And I do not believe it is something where you get to find some in favor and some against. The statute requires you to make findings on all of these. And the last one is, and you have to find extraordinary, exceptional conditions, and you have to find the conditions do not generally apply to other properties in the area, and you have to find that because of these conditions, application of the ordinance without the variance imposes an unreasonable burden on him against use of his property. He wants more borders. The ordinance says he can't have it unless he can get a variance. I'm not going to replow ground from the last item because I think that's going to be an appellate issue since this board voted against some of those findings and yet still voted in favor of the variance. I understand why you did it. But for this one, we had a mediated settlement agreement 10 seconds.
Where this board agreed to have a survey performed. They did that. The survey clearly shows a 47-foot encroachment. They agreed.
You're out of time.
To have that.
You're out of time.
I'd like to hear the rest of it.
They agreed that if there's an encroachment found, they would recommend that 47 feet or the encroached section be torn down, and that has not happened. We are currently waiting for this board to carry out the settlement agreement that they agreed to. We can get into structure if y'all want to. It's in your ordinance. That's what Justice Placonis told her, which is why she signed it. Now she wants to renege.
I didn't sign it. Joni, I need you to speak on behalf.
Can we ask Mr. Bruner a question? Mr. Bruner? Was the mediation binding mediation?
It was court-ordered binding mediation. It was, and the terms of it are right there in front of you.
Okay.
This was.
We agreed to it. Let's make that clear. Newberry County agreed to it. So we have complied. We can discuss this. I can give the BZA legal advice in executive session. I can talk with Mr. Bruner, I can talk with his associates. We've done the survey. All we're doing tonight is applying the opportunity for the individual with the fence to have due process. If they wanted to appeal it, that's what we're doing right here. We're not in violation of the mediation agreement. We are continuing to work with the mediation agreement, and I think that's important for this BZA to understand.
Thank you. That being said, what do we have to do tonight then?
Joni, did you hear that
Joni.
question?
Yeah, I'm sorry. I know that was addressed to me. I think that, like I said, we had to give the gentleman who owns the fence the opportunity to appeal. He's done that. I think that it's clear from the survey, and I think that this BZA needs to understand that survey was done in compliance with the mediation agreement. Because we don't know. Ms. Wertz can't look at a fence and say, yeah, it's in compliance. It's not. We agreed during mediation that we would get this survey done. We did get it done. Took some time. As y'all know, surveyors are very hard to get. They're busy, but we did get it completed, and it shows that the fence is not in compliance.
Did you say not compliant?
Would you agree, Katie? It is not in compliance. It is not. Agreed, Katie?
Correct.
Now, may I ask one question? If, and I don't want to push you gentlemen, but if in the context of this mediated settlement agreement that the board is in the process of carrying out, how does it look if you agree on a path forward, and then during that, this board decides to grant a variance? How would that look if you have agreed to the survey and to recommend that the encroached section of the fence, now 47 feet, tear down, and then this board makes findings of fact to grant him the variance to keep it? I have an answer. It would not look good. And it would not look like the agreement is being carried out. That's all I have.
Ms. Joni, if we, this Board of Zoning Appeals, agreed to this, why is it before us?
That's right. That was my question.
I mean, I don't remember saying we'd go.
This was an administrative appeal that should a fence be allowed within the setback requirements. Y'all agreed with county staff that yes, a fence can be within setbacks. The applicant then appealed y'all's decision to the circuit court, and it went to mediation.
Oh, I missed that part, okay.
Okay.
Yeah. Yeah, we followed the judicial appellate process, and that's why we're here tonight.
Okay, so
We
what
agreed
is,
to the mediation.
what is
Sorry.
the, so this zoning, you said the zoning board's not even passed the new,
There's
Code
a
for the
text
fences, right?
amendment taking fences out of the required setback, but that has been gone through first reading and it has not passed at this.
okay, so what are we voting on here then? If it's not even in the ordinance yet?
It is in the ordinance, but it's
It's proposed to remove it.
proposed to remove it.
Right.
But that's
I
not happening, but that's not happening yet,
I
right?
interpret it that a fence does not have to be but it's not in anywhere that we have found in black and white. So it's gone as a text amendment to get it in black and white. County council has had first reading. It will not be
Yeah.
a text amendment or not a text amendment until
Yeah.
third reading.
So nothing's really changed as far as the zoning?
Correct.
Correct now, it's the same as it was when the fence was forced.
Correct.
Okay.
May I be permitted to respond to that?
Approach.
Now, your ordinances, section 153.231, the definition section, define structure structure. That's what we're here about. Is it a structure to include anything constructed or erected, the use of which requires location to the ground, and I'm going to fast forward a little bit because there's a whole lot of legalese in there, but including, for purposes of this chapter, buildings, mobile manufactured homes, travel trailers, signs, swimming pools, fences. Fences. And that, gentlemen, is in black and white, and it's highlighted on my copy, and that's in your ordinance. I found it. My partner Wesley Peel found it. Justice Placonis found it, which is why this mediated settlement agreement is before you now. The fence is a structure under your ordinance. It should be taken down, and then if he wants to rebuild it, he can then go through the process of submitting plans and requesting a variance. I'm like you. Why are we here? Thank you.
May I say something?
Okay, I'm trying to get,
Go ahead, Ms. Joni. Joseph.
as our lawyer, why, I mean, you want you want us to give, or we're looking at giving a administrative variance or not, is why we're here, Ms. Joni?
No, Katie, correct me if I'm wrong, I think the only question here is the setback. Correct.
Can the fence stay within the setback or not? Just as
Right.
previously we had cases for 3 foot instead of 7 foot to the side property line, we're here tonight of, can he encroach in the 50-foot setback, or does he need to take it back to the 50 foot is the question tonight. It's not about what's in the
Okay.
ordinance. It's been defined that the fence needs to meet 50 foot. Okay, it doesn't. Y'all are deciding here
Correct.
tonight whether he leaves it as a variance that you all approve, or does he take it back to the 50 foot?
Okay, that's clear.
It is clear, but what's clear also is the court decided that it wasn't clear.
No, the court did not decide. We mediated. A mediator doesn't decide. A mediator gets the parties to decide. And the parties decide on the best course of action. The mediator gets you there. So this was not arbitration. This was not court. This was a mediator who listens to both sides and comes up with, or attempts to come up with, something that is acceptable to both sides. What was acceptable to both sides was that we would agree, we would get a survey and find out if that fence was within the 50-foot setback. And we found, getting the survey done, that it was not. Does that make sense?
It
So
does.
the mediator did not decide the issue between the two parties. It was just whether the fence
That's
was
correct.
within the setback or not.
That's correct. And the
And the
mediator agreed, part of the agreement with the mediation was that the county would get, at its own expense, a survey to, in fact, either affirm that it was within the setback or it was not. And the survey came back that it was not. And so what we're looking for from the ZBA this evening, obviously the gentleman who owns the fence had the ability to come before you and speak on his own behalf to say, you know, what he feels about the fence, but the fact remains is that we agreed that if it was not within the setbacks, in accordance with a survey that the county obtained, then we would bring that before y'all to get affirmation that this is what we agreed to. So that's why we're here tonight. We are here tonight to get the ZBA to look at what was negotiated during the mediation and to hear from the property owner, but to understand that we have agreed if it was not within the 50-foot setback, which is our requirement, that y'all would ask the property owner to move it within or take down that portion of the fence that is not within the 50-foot setback.
And for clarification, the mediator was not able to get the parties to agree. Is that correct? They were still?
Oh, no. The mediator did get us to agree. We agreed with that. We agreed with that. There were a lot of things we did not agree on, and Justice Placonis did not he did not make decisions, the parties did. I think that's real important that y'all understand. This was not a court decision. This was not an arbitration. We all agreed to do these things, and we have done these. We spent a lot of money on this survey. That's why we're here tonight, to get y'all to understand this was the direction we were moving in. But in all fairness and in due process to the property owner, he's come before you to state his side. He was not at the mediation. Let's be clear, he was not at the mediation.
Who
Mr.
was
Ginn
at this mediation?
Mr. Ginn was, his attorney, not Mr. Bruner, but Mr. Peeler, and myself, Katie, and that's it, right, Katie? It was just us. And then the mediator.
Okay.
Ms. Katie, do I understand that the county council is in the process of trying to clarify what constitutes a fence, and they're rewriting that?
Potentially. I mean, it's gone through first reading, but it's at a stop. They want a work session to clarify some detailing of fencing. But yeah, I mean, it's before council whether they feel a fence should abide by setbacks or not. And if side setbacks, will it be lake setbacks as well?
Just as a question, can we delay this decision until county council has actually stipulated and what constitutes a fence? And at that point in time, we know exactly what we're trying to
That'd be a
decide.
question for Joni.
We probably will not get there until March. And I would prefer to be in compliance with, as Mr. Bruner pointed out, I'd prefer to be in compliance with that mediation order before March. I understand the BZA's concern there, but to move forward, to be in compliant.
I mean, they're asking for I'm clear, just asking for the variance, whether or not, because all these, if we come back in front of us with these setbacks from the lake contour, and even though they're asking for a variance, because that's how it's written, and we're approving those variances, so we just need to get, I think, through this one here and either say yay or nay.
I was just thinking if.
And I would agree with that, Mr. Chairman. I think that what you're reviewing right now is a situation that falls under the current ordinance, not the ordinance that's to come. And I understand that the ordinance to come may a little more accurately or clearly define what a structure is, where a fence should be, all of that. But for right now, this is a situation that was appealed and mediated under the current ordinance.
Well, yeah, then I'm thinking that whatever that comes about, to get there in March, anything prior to that's gonna be grandfathered in.
Yes, sir. Or considered under the existing ordinance.
Okay.
We're already in February, if we're only waiting until March.
It's not on the February agenda, so I don't think it'll be decided in March.
Can I say something about it?
Come up, Mr. Pierce, please.
Everybody, I didn't bring my law firm of Nelson Mullins in here with me, so I'm just defending myself. But I want to make sure that I understand, speaking to you, ma'am, I'm looking at the Madam Attorney, I know you can't see me.
Okay.
The litigiousness of what's going to happen, if you require me to take this fence down, the thousands of other people in this county, are you going to go back to all of them and make them take their fences back? If not, then why don't we wait until we see what they say on the next hearing? Or, I don't understand why you can't wait. Why the urgency to settle this and make an example out of me? You want this
It's got
done.
nothing to do with you.
Well, it sounds like you want this done now. We can't wait till it comes up in March or April. then I would be grandfathered in. If I would have known all this, I wouldn't have done it because everybody around me has already done it. This is just within 5 houses from me. This is not the hundreds of pictures I have. So this is a much bigger issue. I mean, is it better that I take it back and then plant 40-foot trees to totally block his view all the way down or put a motorhome there? I mean, this is not a chain link rusty fence I'm putting up. It's a $40,000 beautiful fence. It's not harming anybody. This is Mr. Ginn not getting his way and keep coming back down here like every other time that something comes up at this property, which I wanted to retire out and be peaceful and live there. I can't. It's constant. Constant. Do you realize that these two gentlemen live on other sides of this gentleman? This is not just about me or him. It's everybody around Mr. Ginn. So all I'm asking you to do is postpone this till somebody at a higher level can make a decision. I mean, what is the rush? The fence has been up for a year and a half.
There's no rush. We have a mediation order that we have to follow.
Is that just for me or is that for everybody up there at the lake or any property?
It's a mediation order. It's a mediation order for this matter in particular, and we have to follow it. Now, the only way I could postpone following it is if I have the permission of the mediator and opposing counsel.
Well, let me ask you a question, if I may. Do these gentlemen have the authority to grant a variance on this property today?
They do, with the understanding we'd be in violation of the agreement.
Well, that
Which
puts them in a...
creates another...
Well,
we had to grant you due process. You've had that. You can appeal this decision.
Oh, I am, believe me, but the consequences will be much higher, is all I'm saying. Then I'll come loaded with attorneys, and then we'll just, make a big heyday out of it, but, do whatever you need to do.
It's fine. For the sake of discussion, Mr. Bruner, I would ask you if you would be willing to allow us to postpone a decision this evening pending the passing of the change, the text amendment change.
Yeah, respectfully, I don't think so. I think there's no debate that this fence is in violation, and a postponement would only permit the violation to extend further into time.
Okay, thank you. I just needed that on record.
Members of the board, any other questions, comments?
Yeah, I think this
Discussion?
county has put us in a bad situation.
Well,
I don't see the harm in waiting.
I think if we wait, we're gonna have a stronger, clearer definition of what we're trying to resolve.
I agree.
but I think that either way, it's darned if you do, darned if you don't, because if we don't move forward and hear this variance and either approve it or deny it, we're in violation of the order here from the mediator. And if we wait, and whether or not whatever the ordinance becomes, somebody will still come to us in front of this board and ask for a variance, regardless of what the ordinance says. So if we approve it, yeah, we may be against court order. If we don't, it's gonna really be up to the board.
But if we don't approve it, then he's gotta take it.
He's gotta take it down. Right.
He has to move the portion that is outside of the setback.
Right. The 47.
He's gotta take down the 43 feet or whatever it is that they're requesting.
Yeah, let's be clear on that.
Well, then, if the county revises the structure definition, and can he put it back up if it's in his favor?
If it meets requirement.
That's what I say,
If
the
it
way
meets-
the ordinance is written, is in his favor.
He's gonna would have to meet the 360 contour of Lake Murray. You'll have to meet that ordinance.
Depending on what the text
Depends on-
changes.
Depends on how the county council writes
I mean, it
it.
may stay the same, it may not,
Yeah, that's right.
I mean, there's gonna be discussion on that.
I, for one, don't see why we can't wait until we get a definition.
Madam Counsel,
Are we looking for a definition of a fence, or are we looking for a definition of a structure?
We're looking, the question will be, can a fence be within setbacks of Newberry County?
All right, that's the question for us tonight, but what is county?
That's what county council is gonna be seeing is, will Newberry County allow fences to be within required setbacks or not? Or will they be exempt from side and road and just not lake? I mean, it's a matter of, will fences be part of setbacks or not? That's what will go before county council.
But at the time of this appeal, we have an ordinance that says it cannot.
But you were saying that you could go back to the mediator and ask for an extension, did I understand that?
No, sir, what I did was I asked Mr. Bruner, who is opposing counsel, if he would be willing to allow for an extension. If he were to agree to that, then we could jointly go back to the mediator and explain that we have a pending ordinance that could affect the outcome of this matter. But as you heard, he's not interested in that.
Okay. Thank you.
Sure.
May I ask Mr. Bruner a question? Why are you not willing to postpone this? Are you scared that the new definition might go against your client?
Not at all. In fact, quite the
If you're
opposite.
not scared, then let's wait
To what end?
till we get the
It's-
definition, so
it's-
we can make a decision.
And when is that gonna happen? Respectfully, I don't mean to
Well,
argue with you, but there's no guarantee that's gonna
The
happen. or
fence has
reply.
been there for what, a year and a half?
Yes, sir.
What's another couple of months?
Okay, with all due respect, there was no legitimate right to construct the fence in the first place. So if we're gonna start constructing fences in violation of the ordinance and then say, it's here, you have to approve it now.
I'm not arguing that point
Yeah, so
by any means.
that- but it cuts both
We're dealing with
ways.
what's there now, not maybe what should have been or what shouldn't have been, but we're dealing with what's there now. So, I can't see any fair-minded reason not to postpone until we get something back from county council.
And
And at that point in time, you can bring it back, and the board will be able to make a decision.
Okay, let me make sure I clarify something here. Because this whole issue part of the mediation was to force the parties to talk about this very thing. And they paid a mediator, and they spent a whole day debating this very, very thing. Okay?
Were they aware that county council was rewriting their definition?
Your attorney can answer that. I don't know the answer to that.
Okay.
I don't know the answer to that. I don't know if that came later. I will point out that this came after one of the greatest legal minds in our state led the negotiations and got the parties to agree. And the agreement said that if the survey established the encroachment, which it did to the tune of 47 feet, that the county would recommend that encroaching section come down. And that is where, respectfully, your attorney and I have a disagreement because that part has not happened. Instead, we are here, I guess, on a variance application. We've sent a FOIA Do y'all need to know this? We sent a FOIA asking for all the records, and if there's an application signed by this gentleman requesting a variance, I haven't seen it. So
They haven't responded to the FOIA then.
we've gotten records responsive to the FOIA. The application has not been submitted. This is not your traditional property owner signs a request for a variance. This has not followed that protocol.
We have that. It must have just got left out of the email. You can have a copy here tonight. We have a signed application.
Thank you, I'd like that very much. But under this context, yeah, why is he not allowed just to keep it a non-conforming fence? Because we think maybe county council might change the law. It won't be next month because it takes 3 readings. So it'd be April at the soonest. Maybe May, maybe June. How many opinions you think are going to be involved in that? How many people don't want
All
fences?
right, members of the board, we have a variance in front of us, and we've been down this before.
Mr. Chairman, but Ms. Winters says we'll be in violation if we grant this variance. So what are we voting on here?
That's what I understood her to say.
Right.
So what are we voting on here?
We haven't even gone through the findings of facts. You're automatically saying we're going to grant the variance.
That's right. It seems like to me we got one choice.
Then if the board is gonna decide to deny, then you just need to go through the findings and facts and deny it. But we have to have
Sure.
a motion and a vote.
But we can't approve the variance.
You can.
You can.
You can't. we can approve
We'll
it.
be in violation.
Hey, we're going to be in violation either way. So if you approve it, you're in violation. If you don't approve it, then, if you don't hear it, you're going to be in violation. So I see, darned if you do, darned if you don't, so.
Well, then I think we ought to just do what we think we need to do here then.
I think so. I think we do what we feel like what we need to do is best.
That's right. And let the attorneys hash it
Let
out.
the attorneys hash it out.
One last question. Your mediation, will both property owners involved in this mediation?
No,
Just the county and
yes.
this
Mr. Gann,
party?
yeah, and his attorney.
I had no idea this was going on.
Me either.
Yeah, fair enough, Mr. Pierce.
But I gotta pay to take it down if you vote against it. And to your point, if they change the opinion, then I gotta pay to put it back up. And this is gonna affect thousands of people, not just me, so I don't understand why you can't wait. There's thousands of people this is gonna affect. It's not just me.
Part of the reason we
This is the
can't
only
wait is
matter
because
before us.
Mr. Gann, go ahead, Ms. Joni.
No, I just said that this is the only matter that's before us tonight, and that's what we're talking about. If there are thousands, then, we don't have complaints on thousands, we have complaints on this. This is the action item for tonight.
So all of these pictures, man, are 2 houses down from Mr. Gann. They're not relevant. It's just my house because I'm right beside him. Is that correct? I mean, this only pertains to me and my property, not the other properties on the same road, on the same lake. This doesn't pertain to anybody else but me at the moment.
I would have to, I know you're asking Ms. Joni that, but I'm going to make a guess at that the whole thing is all self-policed, self-monitoring.
We
It
are
doesn't
com-
come about until somebody complains about it.
We're complaint-based only, and we
Right.
got
Yeah.
a complaint.
So if he doesn't complain, nothing happens.
That's what
It's all self-monitoring, self-policed.
And in your opinion, if I'm asking you, do you find this fence offensive in any way that you couldn't grant a variance? It's not hindering a view, it's not,
That's would be in the opinion of the board.
Yeah.
Yeah, and the findings of the facts out of this. And, either way, whether we, I kind of got a sense of where this may go. And either way, again, it's a no-win situation for this board. And the attorneys at one point either will be hashing it out.
The The only problem with that is it's probably gonna cost this gentleman a whole bunch of money.
If he tears it down,
Yeah.
right.
Or if he takes it to
Or if
court.
it doesn't tear it down.
Yeah, right.
So I think it's important for this board to understand that what we're doing tonight is not resolving a neighbor conflict. We are abiding by an agreement, a legal agreement, and abiding by the laws of the county. We are not going to settle neighborhood disputes. That's not what y'all do.
Right, but we have the right to make the variance of the laws of the county.
You do.
That's how our board works. So if we want to grant the variance, then we have that right to grant it, regardless of whatever the situation is.
Well, I've heard so much now. What if we agree to grant the variance? How does that affect this gentleman?
He leaves it until further action is taken.
Say again?
Correct, Joni? I'll let you answer
Yeah.
that.
Well, which gentleman are we talking about? The gentleman with the fence?
Correct.
Right.
He's asking if we grant the variance to leave the fence as is, to be able to grant the variance as requested.
Well, you're asking me for legal advice in a public venue, but I would tell you that in all likelihood, we will get sued and the mediator will hold us in breach of the agreement. Again, we're not settling neighbor disputes. We're just looking at black letter law. That's all we've got to do. And if the fence is not in compliance, it's not compliance. And yeah, y'all need to decide whether you want to grant a variance or not, but understand that there has already been legal action taken on it. And a settlement was agreed to. And if we're going to breach that settlement, then that just takes the entire matter into a different level.
So y'all agreed that this board would not give him a variance? That y'all agreed to that?
No.
Okay, well then,
Katie?
we have a right to take a vote then.
Right.
Take a vote. I just want you to understand what is in play already. That's all I want you to understand.
But this is
I'm
not real
telling you
clear.
You don't have the right.
Or
Sir?
the county would not be going to looking at changing the zoning on fences if this was so clear.
It's not clear. That was the recommendation coming out of mediation.
But he was only, at all due respect, Mr. Pierce was only going by what he was told by the county he could do, right? I mean, when he put the fence there, he was officially in compliance. I know there was some issues about what side was the good side and the bad
We
side.
don't permit it, so there was no.
That's what I'm saying. So he was not out of compliance when he done it. Ms. Winters, from the zoning ordinance of the county of Newberry, what do you read a fence is? If you read the zoning 3 months ago, 4 months ago, before any of this came up, what would you classify as a fence? What would you classify it?
Well, I don't have it in front of me, and that was the debate as far as what is a structure and what is not. And so that's where clarification was indicated.
So, back to the board. They're gonna probably get sued either way, so either we vote to not hear it and be in violation of the mediation and get sued that route, or we go through the findings of facts. We either approve it or deny it. If we approve it, we're gonna get sued anyway. So. I'll take a motion either way. Do I have a motion to hear the variance?
we have to proceed.
Well, my opinion was to delay it till county council makes a decision, but according to our county attorney, that would be in violation.
Right. Either way,
Yeah.
either
And if we
way.
grant the variance, we're in violation.
Right.
So I don't really know what's before us.
Well, yeah. It's forced, what they're trying, it's forcing our hands to have
Yeah.
to deny it. And I kind of get the feeling without,
It seems like it forced our hands to deny.
rest it does. Yeah. And we haven't even gone through the findings of facts to whether or not we would approve the variance as requested. And again, we have that right to approve the variance as requested.
Denying it, he would have to set it back to our county ordinance of 50 feet from the lake.
If you deny it, yeah, he'd have to tear that,
Tear
tear that fence out.
it back.
Yeah.
Back to 50 feet.
And we've all been around the lake, we all know what it looks like, we all know what the fences look like.
How much time would he have to remove the fence if we deny it?
I mean, typically, we give someone 30 days to be in compliance. So I would assume, Joni, that 30 days would apply to this matter as well, correct?
Yes, ma'am.
Mr. Wayne, but maybe taking where you're going, if you do deny it, we could grant him 6 months.
Can we do that? Yeah, that's a good question.
Put that into
Do we
our,
have-
put that into,
We deny.
deny it, but gave him 6 months or 8 months to do something with it.
Comply.
Mm-hmm.
Let's see what county's gonna do.
Then see what the county's gonna do.
That might be a good way to resolve that.
I'd be willing to make that motion. Do we need to go through finding of facts?
We'll need to go through the findings of facts.
I don't know which way to vote on that.
Okay.
This is the toughest rock and hard.
All right, there's no further discussion. Let's go through the finding of facts.
I don't see where it makes much difference.
Well. All right, findings of facts, section 153-052. Number one, there are extraordinary and exceptional conditions pertaining to a particular piece of a property.
I agree with that, Mr. Chairman.
I would disagree with that. I don't see that there are any extraordinary exceptional conditions to Mr. Pierce's property.
I disagree also with that too.
Disagree as well? Okay.
Property.
Mr. Bowen?
Yeah, I know it's me.
It's to you, sir.
I'll agree.
Okay.
And I will agree, because I think to this piece of property, this particular case, it is extraordinary.
I'll agree to that as well, that it's extraordinary to that particular piece of property. Number two, these conditions do not generally apply to the other property in the vicinity or in the district.
Well, it hasn't to this point, so I'll agree with that.
I agree also.
I agree also on that too.
I agree.
And I agree.
All right, and I agree as well. Because of these conditions, the application of the ordinance to a particular piece of property will effectively prohibit or unreasonably restrict the use of the property.
I agree.
I agree.
I'll agree on it, Mr. Chairman.
I agree.
And I agree because it would be effectively prohibited unreasonably.
And I agree as well. Number four, the authorization of the variance will not be of a substantial detriment to the adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance.
Agree, Mr. Chairman.
I agree as well.
I agree on that.
Agree.
And I agree too.
And I agree as well. The effect of the variance would not allow the establishment of a use not otherwise permitted in the zoning district, would not extend physically a non-conforming use of land, would not change the zoning district boundaries shown on the official zoning map.
Agree, Mr. Chairman.
I agree as well, Mr. Chairman.
Agree.
Agree, Mr. Chairman.
I'm trying to catch up. Yeah, I'm with the vote. And I agree because this, I agree.
Yeah, I agree as well. All right, so number one, the extraordinary and exceptional conditions pertaining to a particular piece of property, two are in disagreement, four are in agreement. These conditions do not generally apply to their property in the vicinity or the district. We were all in agreement. Because of these conditions, the application of the ordinance to a particular piece of property would effectively prohibit or unreasonably restrict the use of the property. We were all in agreement. The authorization of the variance would not be of substantial detriment to the adjacent property or to the public good, and the character of the district will not be harmed by the granting of the variance. We all agree. Number five, the effect of the variance would not allow the establishment of use non-otherwise permitted in the zoning district, would not extend physically a non-conforming use of the land, would not change the zoning district boundaries shown on the official zoning map, and we all agree.
Mr. Chairman, I move that we grant the variance.
Second, Mr. Chairman.
Do they have anyone opposed? All in favor, raise your hand, say aye.
Aye.
Aye. Mr. Pierce, your variance has been granted.
Oh, but I would wait.
Yeah.
Wait, Mr. Chairman, didn't we propose to grant that variance with the understanding that there would be a 6-month time frame?
And we denied it. It's, we denied the variance.
If we denied the variance?
Right, but we did not deny it.
Thank you for that clarification. I made that motion, but Doug beat me. I'm sorry.
Okay. All right. Miss Katie, here's my agenda.
No, you got, we need to.
No other business.
Yes,
All right,
we do.
yep.
Well, we need to approve the meeting dates.
The meeting dates is the first
go.
Tuesday of every month.
And the only one, June 2nd, I have a conflict. I will not be here.
Are you doing training this year?
Yep.
You are, okay.
Okay. All right. Make a motion to approve the meeting dates, the first Tuesday of each month.
So moved, Mr. Chairman.
Second.
All in favor?
Aye.
All right. Ms. Katie, is that it? Are we ready for a motion to adjourn?
Motion to adjourn, please.
So moved, Mr. Chairman.
Do I have a second?
Second.
All in favor?
Aye.